and gentlemen, please welcome United States Supreme Court Justice Ruth Bader Ginsburg and award-winning author Bryan G. Garner as we conduct an interview by Bill Press.
Good evening, Justice. It's an honor to have you with us this evening.
I'm glad to be with you.
Thank you. And Bryan, good to see you back.
Delighted to be back.
All the way from Texas.
Yes.
Justice this evening, as you know, is an evening to honor those who've excelled this year, particularly in the clarity of their legal communication. So I'd like to begin by asking you, how important is good writing, and what kind of weight do you give your written briefs as opposed to the oral arguments that you hear in court?
For me, good legal writing is tremendously important. I work very hard to write an opinion that will be comprehensible to at least lawyers, but perhaps an audience of intelligent citizens. I tried to write my opinions as short as possible. You know, it takes time to write it short. And something else that I do is I have a read aloud test. I train my law clerks to do that too, because if you can't get through a sentence without taking 2 breaths, then the sentence is too long.
Now that's not something you learned from Vladimir Nabokov, is it?
Oh yes, in a way it is, because Vladimir Nabokov was a great author, a great lecturer, and he was in love with the sound of words.
I think a lot of people don't know about your connection with Nabokov. You might talk about that a little bit.
Do tell.
He was teaching at Cornell University, and my husband of some 56 years and I were in his class. It was the only class that Marty attended regularly. And to this day, I can remember words that man spoke. So, but you also asked a question about the balance between the oral argument. The brief, of course, is by far the more important component of appellate advocacy. It's what you start with, it's what goes back with you to chambers. The oral argument is fleeting. It's a good show. You get a precious half hour per side. That may be reduced to something like 15 minutes if you deduct the justice's questions.
Have you ever been persuaded one way or the other by the power of a written brief, either that makes you feel better about a case or not so hot about a case?
Some briefs have been powerfully influential. I can think of one in the Michigan Law School affirmative action case. It was a brief filed by former leaders of the military academies, saying that the affirmative action program that they have had at all the academies had been very successful, and that it would be impossible to go back to the way it once was, when all of the officers were white and many of the enlisted members were not. That was a very influential brief.
And Bryan, a couple of years ago, you interviewed 8 out of 9 of the sitting justices for their thoughts about the power and clarity of writing. What did you learn that was, that moved them, that they were looking for?
Well, I interviewed judges from all over the country first, and then moved on to the Supreme Court, and was fortunate that Justice Scalia, whom I didn't know, at all at that time, and Justice Ginsburg, who has been my longest friend on the court, early agreed to do the interviews, and then the others fell into line. But the most interesting thing probably was that judges are universally attracted to the same kinds of commonsensical arguments, by and large. They like the same things in terms of presentation. And the political philosophy or the political underpinnings really don't matter as much. Judges pretty much agree on who is effective and who is not effective in terms of just using the language well.
Mm-hmm. You mentioned Justice Scalia. Justice, they say that politics makes strange bedfellows. It seems that the court does too. Washington knows that you and Antonin Scalia, while on opposite sides of most decisions, are good friends.
May I make a correction? It's not most decisions. The Supreme Court is the last word on what the meaning of the Constitution of the United States, but most of the cases that we hear are not of the heady constitutional variety. They are cases about statutes that Congress produces in great number and equally great density. Just to take one example, what we call ERISA, the Employee Retirement Income Security Act, very difficult to penetrate.
Yes.
So that's most of our cases are of that variety and not of the constitutional variety. That means that we will be, Justice Scalia and I, over the term, will be on the same side more often than not.
And the question is, the friendship with Justice Scalia, based on a love of opera or...
And good rhyming.
And good.
And good humor.
Yeah.
Wouldn't you say? Good humor? Good humor.
Yes, and his wonderful wife, Marie.